various railway stations across India.
This means microphone.
Your Lordship,
My humble submission is this Honorable Court was pleased to pass an interim order directing stay of the execution of the decree based on certain conditions.
Selfie pending and the appeal here. Lordship, from the beginning, I am representing your Lordship. If this appeal is heard, everything will go. Even that SLP will become infractions.
SLP will become infructuous.
Lordship,
It's already filed.
Lordship, SLP has been
Are you a
filed.
party before the Supreme Court?
I am responding. So, in the beginning, I am representing.
Are you before the Supreme Court as a party?
Yes, sir.
Yes.
Yes, I am the respondent hearing because the appellant hearing filed a stay petition while filing this appeal. In the stay petition, interim order was passed with regard to payment of that is main profits. As against that order, Lordship, they preferred an appeal before the apex court by way of the SLP. Subject matter of the SLP is whether that order passed, conditional order passed with regard to deposit of that amount is proper or not. That's all.
And why do you say that this is disconnected or unconnected?
This is also, this appeal is through the very judgment and decree of the trial court. That's a condition if it is there, if the, I go to the extent of, if the SLP is allowed. What will be the condition with regard to granted passed by this?
So if the SLP is allowed, then they will not have to pay the mean profits.
That's all.
That is what you're
That's
saying.
all. With
Yes.
regard to possession, Lordship.
Yes. What is the connection between these two? No connection.
There's no connection really.
Then why are you asking for an adjournment?
I'm not seeking an adjournment. I'm only saying my relative is a date for hearing the appeal.
Tomorrow. Come back tomorrow.
Lordship,
Not tomorrow, next week.
Tuesday. Yes.
29th.
But didn't you make a similar submission on the last occasion also?
My lord,
Your face is familiar
my lord, this time.
about Supreme Court and all that.
I did hear it. I have submitted different to your lord's time consultation in the CF along with the memo citations.
Tomorrow.
My lord,
You have made this submission before. Now it comes back to me.
So, my lord, I'm not
Yes.
seeking an adjournment. I'm only requesting your lordship to post the matter next week. 28th that your.
That is an adjournment. That is not an adjournment.
I'm only requesting my lordship to post it 27th to 29th.
Yes. List this matter on Learned Counsel appearing for the. Oh, yes. Next.
Item number 30 and 31, J. Dhananjay Damodar Rao.
For the appellant in case number 169 of 2006,
Yes.
I filed applications to bring the legal representatives on record with the delay petitions.
Yes.
In delay petitions, counsel already appeared. Therefore, these applications may be allowed. Not we need to file persons.
How can we allow it just because he is appearing? He has to file a counter.
We need to file.
What do you mean? He is appearing, therefore we allow?
Because raising
Delay petition means what? Section 5?
Section 5.
This is what, there's abatement and all that?
Yes, 3 applications filed along with the delay petition. If it
No, are you outside the time or are you within time?
is outside time,
Outside time.
yes.
So because he has appeared, we allow the application for saying that there is no abatement?
One second. They filed memo intimating the death of the party.
Yes.
From that time, within 1 week, I filed all these applications.
Very good. Have you filed a list of dates to show that you are within time?
Not the time, within time, I have to calculate the delay from the date of.
So do that. We for abatement matters, we need a list of dates. It's by operation of law. Nothing to do with what parties say or whether somebody agrees. Absolutely a point of law. Yes, file a list of dates. Yes, learned counsel appearing.
Case number 228 of 2006, not the appellant, but they served the
No,
notice.
who is you are the respondent?
Right for the respondent.
Is this another matter
Yes,
or what is
the
it?
matters are there.
Yes, what is it? Yes.
INF, AS number 169 of 2006, just now you watched. Another IP is there, 228 of 2006, wherein not they have filed a lot of petitions, but they are served on me. So I need to file my counter those matters.
No, have you filed your in this matter?
Appellant, 228. 228. Please, sir.
No, so have you filed counters or how many applications are
Yes,
there?
complaint for any counter.
Counter to what?
An application to condone the delay within the LR some records, set aside the amendment and the LR application. IA 1 of 24 to IA 3 of
Yes, how many IAs are there?
3 IAs. IA 1 to IA 3 of
Yes, how
24.
much time do you want to file your counters?
No, we need to 2 weeks time. will be.
Yes, a learned counsel appealing to the respondent seeks to file counter.
Item number 32, Mohammed Abdul Salim.
File for appearance number of 224 after receipt of notice from the Supreme Court as the urgent counsel was not appearing.
What about appellant number 1?
Remember, appellant number 1 died my lord, and with her legal are already on record. We are the legal heads. And the respondent sole respondent.
Already on record by orders of court?
No, no.
Then?
There is no need for filing an application separately, my lord, as we are already on record. We'll take steps, my lord. I have just come on record yesterday.
No, you are already on record pursuant to orders of court.
Not pursuant to, I was
Then-
read, my lord, as an appellant. I just say appellant number 1 died, mother died. But the children are appellants 2, 3, 4, and 5. We have not filed any. The earlier counsel has not filed any formal application to
So
bring us on
you
record.
were already, you are parties to the suit.
Party to the suit. I was already a party.
You are the plaintiffs or the defendants?
Dependent before the trial court.
So the children were already defendants.
Yes, already dependent. That's the reason. So, the appellant 1 died. and sole respondent also died. I said I have filed 3 applications to bring his other legal heirs from the second wife on record. He had a second wife. The second wife also died. He had 2 children from the second
Respondent
wife.
number 1 is the second wife.
Respondent, sole respondent was my father.
Yes.
He had a second wife who was not a party to the proceedings. She also died pending appeal. Left behind 2 children, 1 son, 1 daughter. That application I have filed not to bring them on record. So they are pending numbering the numbers of these questions.
Submission. Yes.
I am for the respondent method. Respondent died method, not appellant. And respondent is having your original plaintiff.
Microphone.
Respondent is died, not the appellant method. That my friend is stand corrected. And method, the respondent was survived by 2 wives. And the first wife.
Just now he said 1 wife, now he said 2 wives.
First wife and her children are the appellants.
Yes.
Second wife, my lord, also died, my lord, her children, my lord, were impleaded, my lord, at the behest of my implead petition. Since, my lord, the respondent was having 2 properties. One was in Madras and one was in Nizamabad district. And Madras property was given to the appellants, first wife. And second wife, due to her death, my lord, her children were given, my lord, during the pregnancy by way of assignment.
You want to make the matter more confusing than it already is.
No, they are already on record, second wife children, by virtue of the impleasement order, my lord.
Past wife?
Part by this on record in this circuit.
This court or what it is?
This before predecessor.
Before a predecessor, that is a coordinate bench.
Yes, my lord, at the behest of our implead petition.
Very well. So who is on record, who is not on record, who wants to be on record? You all tell us all that on the next one. Alright?
Everybody on record.
Everybody is on record.
Yes, my lord.
So then we have to hear out the appeal.
My lord, that also I would like to submit that I don't want to proceed with the merits of the case. This was a dispute between father and
You only want us to decide on the abatement.
No, my lord. Now that my friend has said that the children are already on record and I filed my wakalat just day before yesterday, I'll verify it. They are already on record by the
Children
next.
of both the wives.
Both the wives, appellants from the first wife and proposed parties from the second wife, which applications are still pending. By next date, my
You are
lord,
saying applications are pending, so why are you saying are already on record?
my lord, that I am not aware because day before yesterday I filed my wakalat because this court issued notice earlier counsel was not appearing. My lord, by next date, my lord, I will not confuse. By next date, certainly I will file an application for
So
withdrawal of appeal.
now that you have confused us today,
My lord,
next day you will not.
everything
So
will be.
you file some tables or whatever you want to file.
My lord, by next date, I will certainly withdraw my appeal because I have instructions. I want to proceed with the partition suit as the mother and father both have died. Now the inheritance have opened. So I can now file a partition suit seeking
You
claim
want
under
to
the
withdraw the appeal.
by the next date.
So what did you file before the trial court?
Not trial, before the trial court, my
The appeal
father
arises out of
yes,
something.
suit was filed for declaration of title and injunction by the father against the first wife and children. Mother claimed that she is the owner by way of oral gift which was made by the husband during his lifetime. Now that the father expired, he was declared as the owner. Now that the mother expired, inheritance is open under the Islamic law. So the children have got share under the Islamic law of inheritance. Now proceeding with this case is not of no use because father has been declared as the owner. Now as a child, as children, Lord, I have got right in the property under the Islamic law of inheritance. So instead of proceeding with this case, Lord, I can file a suit for partition, claiming my share. That is the Lord. There is no use.
So you will withdraw the appeal today.
Lord, I will. Lord, should may kindly let me file an application next year by under 23. Lord, should may kindly adjourn it by 2 weeks because just day before yesterday, Lord, I am sorry to repeat. I filed wakalat. I need to verify whether the other.
Very well. And both of you better clarify the facts.
Yes, ma'am.
Because even if we allow the appeal to be withdrawn, we have to see.
Lord, certainly. I will.
Very well. Yes. This is matter on.
Item number 33, Pramod Maliki.
The notes, the 2 notes. It said notes, the notes given by the council. Where is Mr. Malini's room? Yes, Mr. Kolali. Where is, yes, Mr. Kolali, two questions. One is the Perumal judgment of Justice Ravindran, that ultimately says that delay is condoned.
Yes.
Even though that it has those observations with regard to abatement and all that.
Yes.
Sorry, with regard to the delay, yes, condonation of delay,
Yes.
and the steps to be followed under Order 22, Rule 11,
Yes.
starting. It ultimately says that delay should be condoned, taking a liberal view. What do you have to say about that?
Let's aggregate submissions in the synopsis. It is circumscribed in the very same judgment, while at one breath a liberal approach has been advocated, but it is always made that it is subject to certain conditions, like what is the conduct of the person who seeks condonation of delay, whether the application actually shows sufficient cause. It is not merely for the asking. After Perumal Bhagwati Mother said, I relied on another judgment of Bhagwant.
No, Netra Chits as well.
Netra Chits was for the application, for the contention.
Section 5.
They ought to have filed an application. Without filing an application, they cannot.
Yes.
But what your relationship is now asking me is, if they file an application, then since there is a liberal approach, then what do I have to, how do I overcome that proposition?
Yes.
My proposition is, in fact, at the para 11 of my synopsis, what I said, there are exceptions, not exceptions, there are certain conditions where have to be, a certain threshold has to be met by the person seeking condonation. The threshold is his conduct must be free of blemish. Second, there must actually be sufficient cause shown in the application. It can't be, otherwise it would be as good as just filing a paper for the sake of it and saying condone the delay because there has to be legal approach. That is not the way. There has to be sufficient cause.
Well, the next question is Order 22.
Just to,
yes,
sorry, and on the facts, I demonstrated how the application, just one paragraph out of 11 or 12 paragraphs, only bereft of details, and supporting material also do not show what
Paragraph
is yes.
And the other thing is on law. Order 22, Rule 5.3 and Order 22, Rule 9 talks about shall abate, etc. But the language is different from Order 41, Rule 3A. What is the difference according to you? How is there any difference between Order 41 Rule? Because Order 41 Rule 3A is my interpretation, more liberal. What do you have to say about it?
Sir, strictly speaking, even Order 41 Rule 3 uses the word.
Because that promote whatever that case is, I've forgotten that name now. That relies on Order 41 Rule 3A and says that the court should allow. So, what do you have to say to that?
Strictly, if a parallel has to be drawn between Order 41 Rule 3A and Order 31 provisions, then more or less the word shall is used in both of them. So I may not really be able to stand if an analogy is drawn. My submission was, even if an analogy is
that there was only 1 month difference in the other one.
Yes, that was on facts.
But the language of Order 41 Rule 3A and Order 22 more or less substantially same. So how do you want to say that your case should be on a higher footing?
No, on that I may not really be able to sustain my case if I were to go only on that. But that's where my alternative argument was dehorse that the similarity in shall. My alternative and main submission was, in this case, sufficient cause was not.
So your second point is what you want us to go on, that even if we say that it's a curable defect, even then the defect should not be cured because of the insufficiency of cause shown.
Yes.
as required under section 5. That is what your argument is.
So it's a curable defect, therefore the IA can be taken on record, but the IA should be dismissed because it does not give sufficient cause. That is my answer. In fact, well, I mean, much time was taken because initially there was no application. Perhaps I would have only argued on the lack of sufficient
Yes.
cause because initial application was not there. I had to rely on the judgment saying that application is mandated. That's why I had come forward
Yes.
with this. So.
Yes, Mr. Maliki, just 1 minute if you want to say something.
With respect to the first objection, Lordships have raised, saying that the failure judgment, and my friend is saying that the Lordships have already decided in other matter. With respect to second
The
objection.
other matter, there were 7 or 8 reasons for us to say that, yes.
That is the second ground, saying that there are grounds, 7 or 8 grounds. Because I need not have 100 grounds to have the reasoning. I given a reasoning by saying that he is suffering from the upper limb disease, he is within hospital. So that I've also found it only because my number of grounds are less, that doesn't mean that my application cannot be called as sufficient cause. You will watch it, say that there was sufficient cause, it may not be many grounds.
Thank you.
My submission was that one ground is not sufficient, is not sufficient.
Learned counsel appealing for the parties have yes, follow the next one, please.
Item number 34 and 35, MV Pratap Kumar.
Here for the respondent, in the last occasion I had commenced my submission, passed on the synopsis with the judgments. But if I may,
Yes,
if I may, Lord, I would prefer to continue my submission on some other day. Still recovering from my
yes, of course. Tell us when you want to come
not
back.
in the week starting from second, immediately watch it.
Yes, what about fifth? Fifth is ordered, Mr. Pratap Kumar?
Very much, as it was.
Fifth is a Thursday.
Yes, fifth is fine.
Yes, learned senior counsel appearing for the respondents slash plaintiffs. With
Item number 36, MS Om Law Firm.
I'm for the appellant, Your Lordship. In fact, I'm sorry, Your Lordship, yesterday I was not present because I was unwell.
that's
In
what.
fact, Your Lordship, we have come by way of wakalat from the earlier council. The cause list says that the earlier council has sent a notice where already 1 to 4 are being appeared by the senior council. In fact, for the 5 to 8, I mean,
No, this is item number 36.
36.
It just mentions the law firm, name of the law firm.
Yes, sure. I'm appearing on behalf of the law firm.
Yes, so what is the
So
law
in
firm?
fact, Your Lordship, what has happened is the earlier council who was there on the record, he has sent in 2019, it shows as per the cause list. So 1 to 4 are already appeared by the senior council, KV Banu Prasad. In fact, for 5 to 8, I am
So
permitted.
just argue on the point of law. We don't like listening to all these things. What do you want?
In fact, I am ready to argue because there is a 5 to 8 Lordship wanted to know whether the notice is served or not yesterday.
Yes, notice served, not served.
Notice is not served on
My-
5 to 8. Notice is not served on 5 to 8. I am appealing for 1, 2 and 4.
So
That's one-
3 and 5 to 8.
Lordship may order a fresh notice, I will send it because it says return
And
as
there are only 8 respondents.
8 response.
Yes, notice is required to be served on respondent numbers 3, 5. furnish proof of service on the list.
Like,
Item number 37, V.V. Raghavan.
Respondent have, simply my idea was
We have controlled the delay.
no, it's a maximum matter. The find my wife, they care, they was last judgment for husband. I am for the wife, I am a parent. I am already, man, you want time.
You can't, Mr. Raghavan,
The
use a
submission
microphone.
is, says allowed my application to bring additional documents on record.
Yes, yes.
Worships may kindly have this matter under final hearing action anytime.
So we have allowed your 4127.
Yes, Your Worships.
You are enjoying an order, Mr.
That's already allowed. That's already allowed.
Already.
Hello. Yes, this matter on I-1 of 2024 was allowed by the order dated 24/7/2020.
Item number 38, Bhupendra Mahendra.
Response 1 to 3 are not served, my lord. Permitted to take out question.
1 to 3 are not served. You are appealing for whom?
Number 5 to 8. I am for that one in the 4th.
So you need, service of the AS. Service of the AS.
Yes.
Yes. Learned counsel appealing to the applicant seeks to serve respond number.
Item number 39, Manjari and Tanu.
been filed against the partition suit.
Yes,
Which Liability Management had raised objections.
Yes.
Thereafter, I had commenced my submission in IA 1 of 23.
yes.
Not the same request, subject to my reference accommodation.
Yes. And Mr. Ganu, Mr. Suresh Kumar, if council are always ready, and if they come and ask for an adjournment, we can never say no. But there are council who are never ready, so we never give them adjournment.
I understand. I understand.
Yes,
Mr. Gano is my, I have all my love and affection for him. Whatever he says, my lord, in the sense, subject to your lordship's pleasure, there will never be an opposition. Not only for Mr. Gano, for all people, all are.
so love and affection for all the council who seek an adjournment, Mr. Suresh Kumar.
Yeah, your lordship's kindness.
Yes, list this matter. Tell us, Mr. Ganu, where you were.
My lord, 4th or 6th. Because the other matter your lordship have posted
On
on 5th.
Yes, list this matter on 4/9.
Item number 40, Dikshit Bhattacharya.
My lord, I beg to refer the judgment.
Yes.
On the last date of hearing, my lord was pleased to point out that the proof of service of notice that we filed.
Yes.
Proof of service of notice was filed as early as on 5/1/2024 itself.
Yes.
The respondent number 1 expired in that date. Respondent number 2 and 3 are the legalities were represented by the landed family. And respondent number 4 and 5, the notice was served, they have not referred to appear to the ground.
Yes.
It is a matter between brothers and sisters, so they have not referred. And then my lord was also pleased to point out whether the amended copy of the grounds of appeal has been filed. That was also filed on 22/1/2024. Very much available.
Lavanya,
As well as
we do not allow council to make submissions or appear from inside a car or any vehicle. Yes, please mute him. Yes,
My lord, may I submit as being appeal?
yes, yes.
My lordship, before, there's a small correction that has to happen here, my lordship. They have filed a fresh petition.
No, that has been not filed. It has already filed.
This is what,
No, what happened, my lord, thinking that, my lord, that earlier it was not filed, we filed a fresh
No,
one.
what was not filed?
The proof of service and we not amended copy of them. But it was filed immediately after the amendment. And after the service of notice also proof of service was filed. We have verified from it. And meanwhile, we have also filed a fresh one.
How many respondents?
There are now as of today 5 respondents.
Five.
Respondent number 1 expired. Respondent number 2 and 3 are the legalities of the respondent number 1. And they are represented by my London creditor. And respondent number 4 and 5 also notice was served, proof of service has been filed. And they have not referred to appeal before the output.
Yes, yes.
my submission, my lord.
You're for 2 and 3.
That's what, my lord, the rank of the parties has been changed. So I have filed a vacate petition stating for 2 and 3, whereas now the fresh one.
No,
they have-
2 and 3 only.
Yes.
The respondent now they are being shown as 4 and 5.
No, that we are not pressing, Miller. What happened, Miller? Because of the incorrect.
What are you not pressing, Mr. Bhattacharya?
Miller, what has happened, Miller? After my lord has pointed out that there is an office endorsement,
Yes.
showing them as respondent number 4 or 5.
Yes.
We accordingly filed a Miller, a memo, Miller,
Yes.
confirming that. But later on, we check the record, we found we have already filed, Miller, as early as in January and also February, Miller.
File proof of service.
Proof of service. Proof of service was filed on 5th January 2024. They are added as respondent number 2 and 3 only.
Then the respondent numbers 2 and 3 are represented.
Yes.
Yes.
Stop. The respondent number 1 has passed away.
Yes.
Passed away. Vacate against what?
Vacate against the stay petition, my lord.
Vacate against stay petition?
Yes, my lord. We have filed a vacate petition, my lord.
Against what?
Against the stay order.
So tell us, you are saying stay petition. Which stay order? What is the date?
Stay order was on IA number 1 of 2023 dated 18/12/2023, my lord. A small correction has to be carried forward here, my lord.
Yes, learned counsel has been for the respondent numbers 2 and 3 is given leave to correct the vacate stay petition.
Item number 42, C. Bachirati.
May it please, Your Lordship.
Yes.
Your Lordship, yesterday it was adjourned for instruction, Your Lordship, that a memo of proof of service is also filed, Your Lordship, on 14/8, saying that no such person, the notice that was sent was written as no such person, Your Lordship.
Yes.
The order that Your Lordship has directed, that was complied, Your Lordship.
What is the order directed?
For personal notice, Your Lordship.
Complied with when?
By filing proof of service on 14/8/24, Your Lordship.
And what is the date of the order?
16/7/24, Your Lordship.
So you serve the counsel?
Counsel and also the party, Your Lordship, on the respondent and the counsel in the trial court.
Yes, proof of service. Yes, the appellant has complied with the direction dated 16/7/2023.
Notice is not served on this matter. It's not a deemed service. It's not a deemed service. It's written answer.
Yes, Your Lordship.
You need to take steps.
The issue is, Your Lordship, even before this, there's an order by the division bench when the matter was listed before that bench, and it was served through the trial court Nazaret, Your Lordship. There's an order, Your Lordship. Even there's a dispatch number.
This is the recent one.
This is the recent one. Even after is that, yes, Your Lordship, for
Not in the
publication,
absence.
the appellate hearing is not in a position to,
No, but then these kinds of matters, particularly in family court appeals, we cannot pass ex parte orders. We never do. So you have to do something, either fresh notice because it's been returned unserved, as my learned colleague has pointed out.
but through Nazara, trial court's Nazara, it is already served, Your Lordship. This is the second time that we will be sending.
13th August, it was returned unserved. So whether it was sent through the trial court Nazaret or whatever you're saying, is immaterial now. Alright? So then you will have to issue fresh notice or substitute with service, whatever.
Only one submission, Your Lordship. There's a clear order also on the top. The problem is, he's deliberately avoiding the notice, Your Lordship. That is the reason it was specifically.
If it is so, it will be unclaimed. Because it's not claimed.
Only
It's written as no such person.
Yes, yes.
So then-
He's deliberately doing that, Your
So
Lordship.
we cannot come to such a presumption. Alright? Just because you're saying that, we cannot presume that he's deliberately avoiding service.
I only make one submission, Your Lordship, the Lordship's kind permission. There's a specific order passed by the Supreme Bench in this case when it was listed.
Yes.
That it was, this court has specifically acknowledged that the service has been made by the
What is the date of the order?
Yes, yes. 25/6/24, Your Lordship. Awaiting appearance on behalf of the respondent, service is duly served as per the report made available. Case on that day of hearing also, Your Lordship, this court wanted.
Yes, tell us.
This court wanted to give one more opportunity to the respondent to appear through his counsel. That is the reason a week adjournment was given. Later on, the next adjournment, because of some issue, Your Lordship, this docket order was not placed before Your Lordship. And that is the reason, again, a fresh notice was ordered.
Yes, just add a line, please. Council places an order passed by a coordinate bench
Okay.
Yes, we will also consider the order passed by the coordinate bench on 18/4/2024 on the next one. Yes, call up next one, please.
Item number 43, M.V. Pratap Kumar.
Yes.
The claimant before the arbitrator in that is that we under section 37 of the arbitration act, agreed by the dismissal of the section 34 petition.
Yes.
And I made my submissions.
So you said that because there was the amendment to the Specific Act was brought in 2018, therefore still whatever, the Sushil Kumar, that will remain unanswered.
Sushil Kumar would still apply. As the contract was executed prior to the coming.
Because that was prospective.
Prospective, yes. As held by the Honorable Supreme Court, since it comes again,
yes.
Para 59. So that ground melon would still be available. That is the violation of constitutional policy of Indian law, in as much as the binding precedent was not considered by the arbitrator and by the section 34 court alike. That was the first one. The second ground melon is with respect to patent illegality. Because Your Lordship wanted me to summarize the law on how the concept of patent illegality has been interpreted on the courts.
Yes.
So I'll just take about 2 to 3 minutes to set out the brief background as to how this concept of patent illegality has been dealt with and interpreted in under section 34. From a reading of the law that has been laid down, patent illegality was not an express ground initially under section 34(2) of the Arbitration and Conciliation Act. 34(2) of the Arbitration and Conciliation Act, prior to the amendment in 2015, only had the concept of public policy of India. Patent illegality was read into public policy by ONGC and versus Pipes and the subsequent judgments. There were 4 grounds that were considered under public policy. One is violation of the substantial policy of Indian law. Second is interest of India. 3 is it is violation of justice or morality, and 4th one was patent illegality, which was read into by judicial intervention. Subsequent
paragraph 73 or 74 of Pipes.
Pipes, para 73 and 74.
Yes.
And para 31 and 40 of associate plaintiffs.
Yes. 31 is more on perversity.
Perversity, yes. Perversity, was also read into. Now, what has happened, if your lordship sees, the concept of patent illegality has been subsequently it was introduced in 2015, and as interpreted in Sanyong and thereafter in the Delhi Metro Rail Corporation, perversity has been read into the ground of patent illegality. So that portion of ONGC versus Pipes, now finds again, it's inroads into the concept of patent illegality, which is now a statutorily recognized ground available for setting aside the arbitral laws. The law as it stands today, in my respectful submission based on my understanding, under section 34(2)(a), the award is vitiated by patent illegality appearing on the face of the award. It would mean that it has to go into the root of the matter.
2B.
2B. It has to go into the root of 2A, 34(2)(a). 2A. It has to, and it should not be a mere erroneous application of the law. There will not be a reappreciation of the evidence, and there will not be a re-evaluation of the merits of the matter. Those are the broad counters, which your lordship will find under section 34 itself. In addition to that, the way the concept of patent illegality has developed, what we see is that there are 3 fundamental aspects that come into the picture. One is if there is a violation of substantial policy of Indian law, which is, nothing but a reiteration of section 28(1)(a), which mandates that the arbitrator shall decide the dispute in accordance with the substantial law of the contract, substantive law applicable to the contract. That is
28(3).
28(1)(a), and 28(3) is according to the contract. 28(1)(a) is with respect to the application of substantive law.
And 28(3) is
according to the contract, and the trade usages applicable to the transaction. Those are 2 aspects. And another third concept which has been brought into is if it is contrary to the terms of the Arbitration Act itself, meaning that let us assume that it is an unreasoned award, then it will fall under 31(3). 31 subsection 3 of the arbitration. No reasons, and therefore, it's a patent illegality. That is one stream, one thought, of how it has been interpreted. The second stream is concept of perversity and irrationality is also brought in under the umbrella of patent illegality. That is where the arbitrator renders his findings based on no evidence, takes irrelevant material or irrelevant evidence, or ignores vital evidence. Those 3 concepts, which were again, considered in associate builders, reiterated in Sanyong, and also now in the DMRL judgment, which is of 2020. So therefore, to summarize, there would be 4 grounds in my respectful submission, 4 broad heads under which the patent illegality argument may be made. 1, it is perverse. 2, it is irrational. 3 is, the construction of the contract is such that no fair or reasonable person would arrive at those conclusions, in as much as it is not even a possible view to take. And the 4th one, is violation of principles of natural justice, which is more a generic ground than the
So now everything is under patent
illegality.
So nothing remains, all the other subsections are OTOC.
All the other subsections, I would say,
except for all this, everyone should have a fair chance to present his case, 34(2)(a),
yes,
or whatever it is. and should be treated equally and all that.
That's what on the 34(1), my lords.
34(1).
34(1).
Yes.
34(1), and that would also be subsumed under the ground of patent illegality. My lords, they coalesce into each other at some point too. Because it's the way you would I would say, my lords, one would frame their submission, and based on a reading, they would coalesce into each other at some point. But
so morality, public policy, morality is under public policy. All that also comes under patent illegality.
But that is all read into patent illegality, largely. Interest of India, morality and justice. Morality and justice, my lords, has now been not a ground that is applicable, as was the case, my lords, prior to the amendment. But it would be read into the concept of patent illegality. Patent illegality has now become a catch-all, my lords. Whatever, the way I see it is through judicial thought and interpretation, the manner in which public policy was interpreted, my lords, has now been subsumed under the concept of patent illegality.
So even illegality becomes patent?
Not every illegality. Because that would mean that, my lords, I would be permitted to reopen the entire matter on facts and evidence. If it is, my lords, if it is a first appeal under section 96, to draw an analogy to a first appeal.
Yes.
If it is a first appeal under section 96, my lords, the entire suit is up for scrutiny, right from the cause title in the plate. Whereas, my lords, I do not have that kind of liberty of privilege when I am arguing a section 34 or a 37. Because under 37 also, my lords, I am guided by the counters of, I have a very, very narrow. I will not be able to go beyond, my lords, what is permissible area.
You really think so? You don't think that the 2015 amendment has opened up 34?
Whereas the
and made it as broad as you want it to be?
Whereas that would be a very, in my personal view, whereas as an officer of the court and as a lawyer, I think it would all depend upon the way, it is presented to your watchers.
It all depends on whether you want the award to be set aside or you want the award to be suspended.
Yes. Which side of it's a thin line. It all depends upon, and ultimately, it is in your lordship's hands as to where your lordship sees it falling. Is it going to fall on the side where your lordship thinks, or your lordship comes to a conclusion that this may amount to a reopening of the matter on facts and evidence, vis-a-vis a case where your lordship finds that although the evidence and the facts have been taken into consideration, that is not a possible view which any reasonable or a fair-minded arbitrator would have.
Mr. Pratap Kumar, yes, to make your work easier for you,
yes,
and more difficult for your learned friend, the moment you say perverse, yes, you can also look at the evidence which was not considered, yes, evidence which was wrongly considered, or no evidence considered at all.
Yes. On that aspect, my lords, and on that aspect, my lords, largely the entire the award could be opened up. But my lords, there is another limitation there, which I should be conscious of, because my lords, I am the one who is challenging the award. If it has been considered, and if a view has been taken by the arbitrator, and if it is a possible view, those three aspects, those three conditions would have satisfied. Consideration, a view being taken, and that view being a plausible view. Because then I cannot seek your
not an impossible view.
Not an impossible. Yes. A reasonable view, a fair view that could be taken on a consideration of the weights and probabilities of the case, yes, of both sides. If it is a possible view, then in my respectful submission, 34 would be a wall. The contours of 34 melons would be an obstacle. It may not be right on my part to argue that this particular document ought to have been construed or constructed or understood by the arbitrator in this particular manner. Unless I am able to show, like in my first ground, you also will kindly see, again, fundamental policy of Indian law also coalesces into this aspect, patent illegality. I would say, melons, the ground that I have raised as my first ground, where Sushil Kumar has been totally misconstrued by the learned arbitrator and by the 34 court, would not only fall foul of melons fundamental policy of Indian law in as much as a binding precedent has been ignored, binding law has been ignored, it would also, melons, come under the ground of a patent illegality in the context of a perversity, and also violation of the provisions of section 28(1)A of the application.
So you think that it is a plausible view, but you want to argue that it's an impossible view.
Well, as far as my first ground is concerned, well, it is not even a plausible view. A plausible view because of Sushil Kumar.
Yes.
Because in my respectful submission, if there is a binding precedent, it ought to be interpreted and construed in the manner in which it has been held. There is no other possible view because it is a binding precedent. It is the law laid down by the highest court of the land. That is the law that is binding on all of us, including the arbitrator and the Section 34 court. There is no possible view at all. That is why my ground as to violation of fundamental policy of fundamental policy of India is a ground in my respectful submission to which there can be no exception taken. If I may put it that way.
So they misconstrued, the arbitral tribunal misconstrued Sushil Kumar or did not or ignored Sushil Kumar?
Considered Sushil Kumar, but considered that part of the judgment in my respectful submission which is overruled.
Yes.
Because the question before Sushil Kumar is whether a developer has to show that he has been put in possession of the land prior to filing a suit for specific performance. Sushil Kumar said no, that is not a mandatory requirement. The arbitrator says yes, it is a mandatory requirement. There can be no possible view, there can be no other alternative view in that matter in my respectful submission. Therefore, the first ground, if at the cost of reputation, no exception can be taken. I am not arguing that the arbitrator could have taken another view. Maybe I would do that when I'm dealing with my grounds of patent illegality. Because I am, as far as my patent illegality is concerned, my entire emphasis would be on three letters which form the core of my submissions, go to the root of the matter which have been ignored by the learned arbitrator while rendering the findings that he has rendered in the arbitration award. In my respectful submission, if those three documents had been construed like any other fair-minded person would, these are not the findings that would have come out in my respectful submission. Those three documents have been entirely, two of them have been ignored, one of them has been referred to, but for irrelevant purposes. And that will be the thrust of my argument.
And this is your main point for setting aside.
My main point is fundamental policy, Sushil Kumar. This is my additional point. There are 2 points, I am on fundamental policy and patent illegality, and both of them, my endeavor is to convince your lordships on both. I may succeed only on the first point. I am confident that I may succeed only on the first point. I may be able to convince your lordships, and my endeavor has been to convince your lordships that I can succeed only on the first point. But I'll go a step further. I'll also show to your lordships that apart from this, the arbitrator has not considered the matter in the manner in which an arbitrator is required to consider the matter. Because 34.2, if your lordship sees, 34, the manner in which it provides some sort of an opportunity to scrutinize the manner in which the decision-making process has taken place. Otherwise, there is no necessity for a 34. The law could have said the arbitrator's award is final and there can be no further debate or dispute on the award. Because there is this window that is available for me, my endeavor would be that apart from my first ground, I also satisfy your lordships, endeavor to satisfy your lordships that this is a case where your lordships may have to hold that there are patent illegalities on the face of the award, and therefore this would have to be meet its due fate in the form of setting aside of the award. That would be my endeavor. Because
due fate is set aside or sustained?
Set aside. Yes. And the parties will have to go back and agitate the matter. They have been doing so since 2002. Parties have done so for 22 years. That is how the relationship of the parties had developed. And that is what the arbitrator has not taken into consideration.
Great. So, Mr. Pratap Kumar, now that we will do on the next day.
Yes.
You want to open up the award as in the sense of showing us, taking us through.
Taking us there. And for
the award.
Yes, and for that I would be only relying on my note. What I have done in my note is from page 14 onwards.
Yes.
I have set out in brief, in a paragraph-wise manner.
Yes.
What are the findings of the arbitrator?
Yes.
What are the patent illegalities that I have set out as grounds before the 34th court, and how the 34th court is dealt with it. in one, my lords, in one table, I've tried to put everything in one table so that it gives a bird's eye picture, and I don't need to, my lords, go back and forth as to how I have, my lords, agitated the matter before the different fora. And this will suffice, my lords, these will be my grounds. I will take about, if your lordship permits me on the next occasion, about 30 minutes to go through this, and I'll wrap up my submissions.
Thank you. And in any case, Mr. Raghuram had said that he will take another date.
Yes, please.
Yes. Learned counsel opinion for the
And 45, Rajendra Joshi.
In my submission.
just 1 minute. We just want to check a provision of the arbitration. 2A is within brackets and A is capital. 2A is within brackets and A is capital. Yes.
Yes. Concluded my submission to not so taking up the appeal for hearing. It's coming up with submissions with response.
Representing Judicial Salary, our senior counsel is not well since last night, Your Worship. He is hospitalized. Kindly post this matter next week, Your Worship. He is ready with the arguments, Your Worship.
Learned counsel opinion for the respondent.
Item number 46, Srikanth Hariharan.
For the appellants in this matter, my lord.
Yes.
My lord, as per the court's direction, booklet is already filed, my lord, and it is posted. Final hearing may be posted after 2 weeks. As senior counsel is representing this matter, my lord.
Oh my lord, I use this message.
Yes. Learned counsel opinion for the. This is the third consecutive adjournment paid on behalf of the appellant. Stop. This matter on 30/8/2024 as a last chance. The paper books are already before this. Next.
Item number 47, Mohammed Shafiuddin.
Well, I am for the appellate in this matter. Previous occasion, this honorable court has ordered for the notice and same has been served.
So you are appealing for the respondent?
I am appealing for the respondent.
Yes.
It's a memo of.
So are we, do we have to hear out the appeal or is there any IA?
There is an IA filed along with an appeal, IA 1 of 2024.
What is that for?
It is for suspension of the.
So you want to argue the suspension or the appeal?
For an appeal. Lord, this IA may be considered as not pressed and we are ready for arguing the appeal.
Very well.
Kindly post.
IA 1 of 2024. Who is R2?
R2 is a NGO.
NGO?
NGO, which has passed.
Why have you made the NGO party? It's an HTA.
Yes, my lord. This NGO named Sada-e-Haq Sharia Council, it has passed an order. Agreed with an order, we have filed a main FCOP in the trial court, additional family court.
But have you served the NGO?
Yes, we have served the NGO, but the notice was not yes, it was unsent, stating that addressee is not found.
Very well, then you will have to serve the NGO.
It has become different. They are closed down. The NGO.
File an affidavit to that effect, please. The respondent number 2,